Welcome to the deep dive. Today we are strapping in for a really high stakes look at a major legal showdown in the Delhi High Court on Tuesday, 18 November. It's one affecting thousands of retirees, the fight for comprehensive pension rights involving State Bank of India pensioners. I'm Nisha Bhattacharya and my co-host is Anil Agrawal.
We've got a detailed summary of the proceedings from the Tuesday hearing, and our mission today is to cut through all the procedural thicket. We want to distill the crucial legal maneuvers, uncover the core plaintiff demands, what's driving this long-running dispute, and explore what happens next.
And this isn't just some legal technicality. This is about whether massive established statutory rights will be honored by the government or whether it will continue to drag its feet as it has done for over 2 years.
And that's really the key. What's so fascinating here is that while the focus of this specific hearing was, mostly on procedure, just making sure the government is actually taking action, the underlying stakes are just extraordinary.
We're seeing a fundamental conflict over statutory obligations, equity, and I think most critically how the courts define and enforce retrospective financial relief.
In one corner, aggrieved and disenfranchised retirees, many in the autumn and winter of their lives, and the other corner, a government that has turned judicial foot-dragging into an art form, immune to the injustice suffered by the elders of India's banking and other PSB retirees, a common affliction in complex service jurisprudence involving India's DFS.
A classic battle then.
It is. A classic battle between bureaucratic delay and the rights of the elderly.
Okay, let's unpack this and maybe establish a map of the battlefield first because we're dealing with multiple cases being heard at the same time. Let's clarify the main parties so you know exactly who's fighting whom.
Certainly. So we're looking at two main sets of petitions, but they both address the same central grievances. On one side, you have petitions filed by the GOP, that's the group of pensioners, and some related cases. They're primarily challenging the State Bank of India itself.
And the second key case?
That one is brought by the FSBPA, which is the Federation of SBI Pensioners Associations. And what makes their case so crucial is they've named both SBI and the Union of India as the central government as respondents.
So bringing the government in directly.
Exactly. And that's key, because the relief they're demanding requires official government action. The bank can't just resolve this alone.
So, we have three players, the retirees, the bank, and the government. Now, let's get to the heart of it. What are the two core demands they've been fighting for years?
The demands are very specific, and they have huge financial consequences. First, retirees are seeking pension updation.
Pension updating.
Essentially, they're demanding parity. They want their pension formulas revised and brought in line with those for central government pensioners.
Okay, so that's the first one. What's the second?
The second, and this is the absolute flashpoint of this entire legal fight, is the demand for retrospective relief. It's not enough for them to get the higher pension going forward from, today. They demand that the updated formulas be applied retroactively, stretching way back to the date they believe they were legally entitled to them.
And I'm guessing that second demand is what's really keeping the lawyers so busy.
Yes.
So their core argument rests on equity, on the law itself. Implementing these new formulas, only moving forward. They're arguing it doesn't just shortchange them, it actually violates the obligations laid out in the SBI Act 1955.
That's absolutely right. Think of it this way. If the bank or the government had complied with the law years ago, those pensioners would have been getting higher payments for a decade.
Right.
So by only offering relief today, they're effectively erasing years of rightful backlog payments.
Okay, let's pivot to the hearing on November 18th, 2025. It wasn't a final judgment, but more of a critical procedural check-in. What was the Delhi High Court focusing on that day?
The focus was purely on administrative accountability, on compliance. The court was reviewing compliance with an order that wasn't even from this year. It was from way back in November 2023.
2 years ago?
Exactly. And that 2023 order was very specific. It instructed the Union of India to finalize and publish a formal Gazette notification. That's the legal instrument in the official government rule book that makes these changes binding.
For you listening, when a court demands a Gazette notification, what exactly is that? Is that the final rule that sets the new benefit levels?
It is the final official rule book. It's the formal publication that amends the regulations and statutes that govern these pensions. Without that Gazette notification, the government hasn't completed the legal step to implement any changes at all, prospective or retrospective. So the hearing on 18th November was basically the court asking the Government of India, DFS, why, after 2 full years, is this Gazette still not published?
And what was the government's response to that pretty stunning delay?
Government Council requested yet more time.
You're kidding?
No, they said they were still struggling to comply. It's a classic indicator of how hard it is for Indian courts to enforce compliance against large governmental bodies.
Wait, hold on. They were ordered to produce this 2 years ago?
Yep,
To request 8 more weeks in late 2025. Is that just standard pushback, contempt, or does it signal outright resistance?
I'd say it's likely a mixture of all three. It's standard bureaucratic inertia, for sure. But in a case with a massive bank like SBI, with hundreds of thousands of retirees, any updation has budgetary implications in the billions. So the reluctance is almost certainly tied to the financial liability, especially that retrospective part. But the court, while it acknowledged the request, it also set a very firm boundary. They granted a specific deadline of 8 weeks for the government to issue that Gazette notification.
So the immediate action is placed squarely back on the government's shoulders, hard deadline. And until that notification is published, the matter remains what? Sub judice?
Precisely. The case is technically pending this government action, but this really highlights the court's masterful tightrope walk. They insist on procedural compliance, forcing the government to act, but they're also keeping the door wide open for future legal challenges. They're basically saying to the pensioners, if what they publish isn't good enough, you have the guaranteed right to come back here.
That brings us perfectly to the crux of the conflict then. The issue that everyone knows will define whether this legal fight keeps going into 2026, retrospective relief. The petitioners made sure during the hearing that the court understood that just publishing a notification isn't the finish line.
That's right. They were very clear. They reiterated that mere prospective implementation would not resolve the underlying dispute. Their core prayer, the thing driving this whole thing, involves achieving retrospective pension revision. And crucially, they want interest on those accumulated arrears.
Let's just dwell on the arrears and the interest for a moment.
Okay,
What kind of money are we really talking about here? If the case has been running a decade and the entitlement goes back even further, what's the significance of adding interest on top of that?
the significance is huge. This is where you see the real financial stakes. When they talk about retrospective relief with interest, they aren't talking about a few extra months of payments. They're talking about a potential lump sum covering payments they should have gotten for, say, 15, maybe 20 years. And that's adjusted for inflation, compounded with interest.
Wow.
For an individual retiree, that's the difference between struggling and financial security. It's a life-changing amount of capital, and that's why the government is so resistant.
And if we connect this to the legal strategy, the administration's response about what prospective even means is critical. The court itself noted a real ambiguity there.
Absolutely. This raises a key question the court had to address. When the administration says the revision will be prospective, that statement is, well, it's fundamentally ambiguous. The court pointed out this could mean one of two things, and the difference is enormous for every single retiree.
Okay, let's break down those two interpretations, maybe with a simple analogy.
Okay, sure. Imagine a bank announces a new, higher retirement benefit plan. Interpretation 1, and this is the least favorable to the pensioners, is that the new plan applies only to employees who retire after the date of the notification.
So if you retired yesterday, you get nothing extra. That sounds brutal.
It is. Interpretation 2, which is better, is that the new higher rate applies to all existing retirees, but only for the period after the notification date.
So you get a higher monthly check starting today, but you still don't get any back pay from the last 10 years.
Exactly. And the pensioners who are demanding relief going back years are saying neither of those definitions is good enough.
But I guess the second one is at least a partial acknowledgement.
It is. And the tension is palpable. Which definition will this upcoming Gazette notification adopt? If they choose interpretation 1, the legal fight restarts immediately, probably with even more force.
And the petitioners are using every tool they have to challenge this whole drawn out process, right?
By the way, if you're enjoying this podcast, please subscribe, share, and like. It costs nothing to do all three.
Getting back on track, they cited non-compliance with the SBI Act. They argued this delay and offer of only partial relief, it undermines what they call judicial efficacy.
Strong words. For you listening, judicial efficacy means can the court actually enforce its decisions and provide real relief in the face of administrative inertia?
So they're saying the system is failing them. They're saying the administrative step, the Gazette notification, is being used as a stalling tactic. For SBI pensioners, the precise language, the scope of the specific Gazette notification, it's absolutely pivotal.
It's the action that determines if their core grievance, that retroactive application of benefits, is addressed at all. And the strategic implication, which the court affirmed, is that they retain the right to immediately come back and challenge it if it falls short. That door remains wide open.
So let's bring it all together. Let's summarize the current procedural state of this long-running battle. What's the definitive timeline for the next chapter?
Well, the procedural state is highly conditional. The court has enforced that strict 8-week deadline for the Union of India to publish the notification. But the substantive core, that deep conflict between retrospective versus prospective relief, that remains completely unresolved.
So the notification itself could just become the next battlefield.
I think we can anticipate it will immediately become the focus of new arguments.
And what timeline did the court specify for that post-notification review? When do we check back in on this?
The court directed that the matter would resume on May 2, 2026, and that date is specifically set aside for this post-notification review. It gives everyone time to assess the exact content of the government's publication and figure out if it resolves or, more likely, exacerbates the dispute.
So what does this all mean for you? The learner tracking this case, what's the strategic takeaway here?
I think the strategic takeaway is understanding how high courts have to manage the brutal reality of administrative delay while rigorously protecting petitioners' rights. The court has to enforce statutory compliance and ensure equitable relief, but it can't just write the rules itself.
Right. It has to force the administrative arm to comply. And that struggle, that back and forth between the judicial deadline and bureaucratic resistance, that's the real story here. It's a textbook example of institutional friction.
What an illuminating look into the legal maneuvering behind retiree rights. The tension is so clear.
The court has directed a procedural step, the Gazette, but the underlying substantive issue of whether that notification will grant retrospective application with interest is still just this huge unresolved elephant in the room.
Absolutely. And as we finish this deep dive, maybe consider this provocative question for yourself. Given that the court itself acknowledged the ambiguity around the definition of prospective, what administrative clarity is required in the upcoming Gazette notification to truly satisfy the principles of equity and judicial efficacy the petitioner cited?
I mean, does the government need to explicitly state the start date for the benefits or define which specific groups get the change to avoid everyone coming right back to court? Or is that ambiguity just a tactic designed to invite more litigation?
And that is the question that will hang over this case right up until May 2026. Thank you for joining us on the Bloggerian Deep Dive. Be sure to follow up on that May 2nd, 2026 resumption date for the next major development in this critical fight for retiree justice. Nye!